attorney Laura Anthony, founding partner of Anthony P. LLC, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the amendments to the definitions of accelerated and large accelerated filers. As I mentioned in the last LawCast in this series, the SEC recently amended the definitions of accelerated and large accelerated filers to exclude smaller reporting companies that have less than $100 million in revenues. The topic of disclosure requirements under Regulation SK as pertains to disclosures made in reports and registration statements filed under the Exchange Act and the Securities Act has been prolific over the past few years, with a slew of rule changes and proposed rule changes. Regulation SK, as amended over the years, was adopted as part of a uniform disclosure initiative to provide a single regulatory source related to non-financial statement disclosures and information required to be included in registration statements and reports filed under the Exchange Act and the Securities Act. The SEC disclosure requirements are scaled based on a company's size. The SEC categorized companies as non-accelerated, accelerated, and large accelerated in 2002 and introduced the smaller reporting company category in 2007 to provide general regulatory relief to these smaller entities. The only difference between the requirements for accelerated and large accelerated filers is that large accelerated filers are subject to a filing deadline for their annual reports on Form 10-K that is 15 days shorter than the deadline for accelerated filers. The filing deadlines for each category are: a large accelerated filer must file its 10-K within 60 days after its fiscal year end and its Form 10-Qs within 40 days after the end of each quarter. An accelerated filer must file its Form 10-K on an annual report within 75 days after its fiscal year end and Form 10-Qs within 40 days after each quarter end. A non-accelerated filer must file its Form 10-K within 90 days after its fiscal year end and its Form 10-Qs within 45 days after the end of each quarter. Same as non-accelerated filers, smaller reporting companies must file their Form 10-Ks within 90 days after the end of each fiscal year end and its Form 10-Qs within 45 days after each quarter end. Significantly, both accelerated filers and large accelerated filers are required to have an independent auditor attest to and report on management's assessment of internal controls over financial reporting in compliance with Section 404B of SOX. Non-accelerated filers are not subject to Section 404B requirements. Under Section 404A of SOX, all companies, big or small, that are subject to SEC reporting requirements, again, regardless of size or classification, must establish and maintain internal controls over financial reporting, have management assess to such internal controls, and file CEO and CFO certifications regarding their assessments. I'm securities attorney Laura Anthony, founding partner of Anthony P. LLC and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.